Hello and welcome to this presentation from Crescent Purchasing Consortium, where we're going to talk about the basic fundamental principles of contract law. The objectives of the session are as follows: to understand how contracts can be formed, to understand some of the terminology that's used in contract law, to recognise how perceived simple contract changes can impact across the whole contract, to understand what makes up boilerplate clauses, to understand the battle of the forms, and to introduce best practice when managing contracts within your institution. So what goes into a contract? Well, there are key legal principles that are the fundamental building blocks of every contract, and we'll talk about those in a little more detail in this presentation. Ultimately, a contract that is acceptable to you is one that presents the least risk, or a risk profile that you believe is balanced and appropriate to the subject matter of the contract. So there are four fundamental legal elements that must be in place in order for a contract to be formed. And these are offer, acceptance, consideration, and intention to create legal relations. Firstly, we'll look at offer. And that simply is the offer to buy or sell goods or services. Acceptance is the acceptance of that offer to sell or buy the goods or services. Acceptance requires consideration to be true acceptance. Now that in itself doesn't mean an awful lot. So what is acceptance? Well, acceptance is agreement between the two parties to actually complete the sale. But for that acceptance to actually be true acceptance and be legitimate and legal, there needs to be consideration. So what's consideration? Consideration is the exchange of something of value for the goods or the services. Normally this is money, but it can be other goods or services. For example, back in medieval days when we had the barter system, that would have acted as consideration within the contract. And finally, there needs to be an intention to create legal relations between each party. Each party to the agreement wishes the agreement between them to be legally binding as a statement that simply says, we agree that this is a formal contract between us, and in doing so, we both intend to create a legally binding contract between us. And if an offer is not accepted but a new term is introduced, what do you think that becomes? I'll give you 10 seconds to have a think about that before moving on. If you said counter offer, then well done. All that's happened is one of the parties has not accepted the current offer under the existing terms and has made a counter offer to the other party. What that now means is that there needs to be acceptance, consideration, and an intention to create legal relations in order for that counter offer to be a legally and valid binding contract. So one of the questions we're often asked is, can a contract be created verbally? The simple answer is yes. If you can agree commercial terms either on the phone or in a meeting, then you can form a contract. A simple example of this would be on the telephone inquiring about the price of copy of paper from a merchant, agreeing that price and then placing an order for delivery the following week. In doing so, you've satisfied the criteria of offer, acceptance, consideration, and an intention to create a legally binding contract. The next question we're often asked is, can a contract be created simply by the act of doing or not doing something, so by the act of conduct? Again, the simple answer is yes. Just because there isn't a formal written agreement or contract in place, if you act upon agreed terms, then a contract is said to be in place. So for example, I've telephoned the supplier to ask for a weekly delivery of copy of paper, and I have deliveries over a 4-week period without a formal purchase order being placed. Then I've done two things. I've first of all verbally created the contract, and then secondly, in receiving multiple deliveries, my conduct in accepting those deliveries on a weekly basis means I've just ratified that contract yet still further. So, is a supplier bound by any pricing they publish in a catalogue, or more nowadays on their website? The simple answer is no. Catalogues and websites are mainly what's called an invitation to treat.
and no offer is being made until the potential buyer makes an offer to buy and the supplier completes the contract by taking the payment and providing the goods or services. So in simple forms, if you order something on a website, until the point at which your payment is taken, there is no contract. It's worth now considering whether or not all employees within an institution have the capacity to enter into a contract on behalf of their institution. Normally the answer is no. All organisations should clearly have a list of designated contract signatories that is held out for all contracts within the institution. Issues arise where somebody who's not authorised but believes themselves to be authorised signs something on behalf of the institution which the other contracting party also believes is legitimate. These tend to then cause problems for the institution when you try and get out of a contract. And I've seen this in multiple occasions, particularly with small contracts that may have been signed by somebody who had no right to sign a contract, but ultimately has held themselves out as having legal capacity on behalf of the institution. These tend to be things like photocopier contracts, franking machine contracts, etc., that don't come to light for many years, and normally when there's an excessive bill lands for the goods or services that have been procured under the contract. The way to offset this, as I say, is to have best practice, have an agreed checking and approval route with all contracts executed at SMT level, and have this clearly designated within the financial regulations for your organisation. So another fundamental principle of contract law is the term ultra vires. In essence, this means that organisations cannot enter into any contracts that are beyond their power or purposes. So, for example, an educational institution shouldn't be signing a contract for buying a 747 jumbo jet, as they don't fly aeroplanes across the world.
So what is an express term in a contract? Simply put, this is where there's a provision in the contract that's clearly, directly and unmistakably communicated in written or spoken words. So these are normally terms that are agreed by the supplier and the institution as being expressly provided for within the contract. So this can be things such as, we will deliver your goods on Monday the 1st of December at 12 noon. So that is an express term pertaining to delivery within the contract.
So we've considered express terms. Let's now move on to implied terms. And one of the questions on implied terms is the sale of goods an implied term in a contract? The simple answer is yes. The Sale of Goods Act is an act of Parliament which is implied by statute or law. While the basic principles of contract law are quite straightforward, sometimes there can be a mistake in the way that a contract is interpreted. So we'll now look at the three types of mistake that can happen in a contract. The first mistake is a unilateral mistake. For example, in a contract for the sale of screws, one party may incorrectly believe that the word screw refers to a Phillips head screw, when in fact the term refers to standard type screws. If only one party holds this mistaken belief, but the other is clear on the meaning of the screw, then this could be called a unilateral mistake. The second type of mistake is a mutual mistake, where both parties agree that there is a mistake in the contract terms. And finally, there is what is called common mistake, where both parties have the same mistaken belief as to the facts. The next point of consideration is a simple question. Can a contract exclude liability for death or personal injury? Well, the simple answer to that is no. That can never be excluded from a contract. We're now going to consider title and ownership of goods. And one of the questions around that consideration is, when should a supplier transfer title to goods? Well, as a supplier, you would like to transfer the title of any goods that you sell when payment is made. So title is actually owning the property within the goods, and it's common practice for the supplier to hold on to the title until they have been paid. So conversely, when should a buyer seek to transfer title to themselves? The buying position is normally to try and transfer title in goods upon delivery. This allows the buyer to use the goods or services before paying for them. It can create issues if goods or services are subsumed into another part of the business or another product, and the buying company goes into administration. So any terms and conditions in relation to title should be checked very carefully before agreement. We previously considered mistaken contracts and how a mistake in a contract can lead to that contract being terminated. Another clause in all contracts is force majeure. This too can lead to contracts being terminated. But what does the term force majeure actually mean? Simply put, it's an unforeseen event that is beyond the control of the parties. So a good question to ask here is, would a factory strike, which is normally included in most contracts as a force majeure event, actually be force majeure? The answer is it depends. If the strike had been directly caused as a result of the actions or inactions of the selling company, there's a strong argument that it's actually a foreseen event that is within their control. On the other hand, if there was a lightning strike that came on very short notice, then that could potentially be seen as force majeure. Contracts can have that element of the force majeure clause removed if you deem it necessary. We've also seen recently with the COVID-19 pandemic that has been used as a force majeure event to terminate contracts. It's also worth noting that whilst you can terminate if it is true force majeure, you should have an option for contract variation built into your contracts as well. So it may well be that you can vary the terms of the contract during the unforeseen event so that both parties come out of the event at the other side and still contractually working together. So what happens in contract if, for example, you have some faulty goods and you need to deal with them under the contract? Normally, let's take an example here. If an institution purchases PCs without an additional warranty and that PC stops working in month 13 at the end of the 12-month warranty, the question is, would they have any legal right to a replacement? The argument may be that the warranty expired after 12 months. However, whilst that is the case, the courts will also consider what a reasonable person would consider to be the expected lifetime of the PC. In reality, a reasonable person would not expect a PC to become faulty after 13 months. So in essence, you would be entitled to a replacement. We're now going to consider whether, when it comes to paying our suppliers, is it best practice to allow the right of set-off within our contract terms and conditions? No is the answer. A set-off allows for debts between parties or different contracts to be taken into account. It's best practice that each procurement contract is separate and distinct from all other business activities that you may be undertaking with multiple suppliers and their multiple agencies. So another term that you'll find in contracts is time of the essence. Simply put, time of the essence means that where a date for performance is specified, then that date is the latest date by which performance will be accepted. Now, performance can be either the delivery of goods or the performance of services. Another query is, what is the Battle of the Forms? The Battle of Forms exists where parties constantly send each other terms and conditions through the various stages between purchase and payment, hence the term the Battle of the Forms. So for example, if you send a purchase order with your terms and conditions on and the supplier returns a acknowledgement of order with their terms and conditions on that you then rebut, but the supplier then on their delivery note has terms and conditions on the back that you sign, then the supplier will have won the Battle of the Forms, as the last set of terms and conditions that were used are the ones that apply. This is why it's always best to have an overarching contract between yourself and your key suppliers so that the Battle of the Forms cannot occur. These are the standard clauses that are always found in commercial agreements, and on the left hand side there you can see a list of some of the headings that are used for boilerplate clauses within all contracts. And I'll just leave you to have a look down those, and you'll see that those are usually the boilerplate clauses that you will have in your contracts. So finally, let's just consider the objectives of this short training session today. Firstly, we were going to understand how contracts can be formed, and we've done that. We're also going to understand some of the terminology used in contract law. As this is a basic level course, we have understood some of the basic terminology that's used, but there are many more terms that you will need to learn throughout your procurement journey. We were going to recognise how perceived simple contract changes can impact across the whole contract, and we've done that with some of the rights of termination just on the simple clauses that we've looked at today. We were going to understand what makes up boilerplate clauses, and these are the clauses that are in all contracts, hence the term boilerplate. We're going to understand the battle of the forms and why it's necessary to have an overarching contract between yourselves and your suppliers that puts your objectives of contract first. And finally, we're going to consider best practice when managing contracts in your institution to ensure that only relevant and pertinent people sign those contracts to mitigate risk going forward. Finally, if you require any further information about this course or any of the CPC products and services, please do contact any of the contracting team, our regional procurement advisors, or the CPC help desk on any of the medium below. Well, we hope you've enjoyed this course, and we'd just like to point you to our brand new CPC e-learning portal, which offers an introductory course to the fundamental principles of best practice procurement in education. For further information, please do contact our help desk, and they'll be delighted to give you access to that particular course.